Shri Narendra Modi, Honorable Prime Minister of India, Shri Sharad Arvind Bobde, Honorable Chief Justice of India, Shri Ravi Shankar Prasad, Union Minister for Law and Justice, Communications, Electronics and Information Technology, Honorable Judges of the Supreme Court of India, retired Judges of the Supreme Court of India and the retired Chief Justices, Shri K.K. Venugopal, Attorney General for India, respected dignitaries from across the globe, Honorable Chief Justices and the Judges of the High Courts, Solicitor General of India and respected law officers, Chairman Bar Council of India, President and members of the Executive Supreme Court Bar Association, respected advocates, directors of judicial academies, member secretaries of the legal service authorities, members of the press, ladies and gentlemen, good morning. It's a privilege to welcome distinguished judges from various countries to this land of ancient civilizations and multifarious cultures, and where we strongly believe in unity and diversity. Atithi Devo Bhava, meaning the guest is God, embodies the traditional Indian philosophy of revering guests with the same respect given to God. We hope to keep you comfortable during your short stint here at Delhi. On behalf of the Supreme Court of the largest democracy in the world, which is the sentinel on the Quive way, with respect to the fundamental rights of the citizens of this country, I extend a warm welcome to all the delegates to this judicial conference. Established in the year 1950, the Supreme Court of India has constantly strived to fulfill its constitutional obligations. Over a period of 70 years, the judges of the Supreme Court have been responsible for the independent and impartial dispensation of justice, apart from protecting the guaranteed rights of the people. I had accompanied the Chief Justice of India to St. Petersburg for an international judicial conference in May 2019. Impressed with the experience at St. Petersburg, the Chief Justice of India proposed an international judicial conference in India, which would facilitate cross-fertilization of ideas between the judges of this country and their counterparts from across the globe. He believed that the conference would also provide an opportunity to the judges of the Supreme Court of India and the High Courts to learn from the experiences of the distinguished judges from abroad. The insight of the Chief Justice of India has taken shape in the form of this conference with the theme Judiciary and the Changing World. Justice Oliver Wendell Holmes Jr. once famously said that the life of law has not been logic, it has been experience, indicating the need for constant evolution of laws. He noted that the prevalent moral and political theories, intuitions of public policy, evolved or unconscious, even the prejudices which judges share with their fellow men, have frequently been the reasons for evolving law through legislative and judicial measures. Evolution of the law assumes importance because the law represents the progress of a nation and its social conditions. And the failure to evolve the law in accordance with the changing circumstances often leads to injustice. Each legal system has its own method of evolving laws, but in most such systems, constitutional law plays an important role in ensuring that the changing circumstances are reflected in the law. This is so because constitutional law is understood to be constantly evolving. Therefore, it becomes incumbent upon the judiciary to provide constitutionally sanctioned methods of interpretation through which the laws are shaped to reflect the changed social facts. It is this vital role played by the judges in accommodating social, economic, and technological advancements in the law that we seek to address in the next 2 days. Aaron Barak, the famous Israeli jurist, once noted that the role of a judge is to help bridge the gap between the needs of the society and law. Hence, whenever the doors of the courts are knocked, the courts will have to attempt to provide an interpretation which accommodates the changed circumstances. However, the courts will have to tread carefully in doing so because in the process of refurbishing a constitutional provision, the object sought to be achieved by the Constitution cannot be defeated. All 5 topics for discussion in this conference in the next few days involve instances in which the courts are required to interpret laws to account for changed circumstances. In order to illustrate the point, the right to privacy, which is a topic for panel discussion and which has been recognized as a fundamental right by the Supreme Court of India, has truly transformed in shape and form in the last 60 years of its existence in Indian law. While it was initially limited to dealing with issues of surveillance and protection of epistolary communications, it has now evolved to protect not only telephonic conversations, but also protection of online data. It is this challenge of interpreting unchanged laws in light of vastly changed social and political contexts which courts constantly grapple with. Judges across countries would presumably deal with such issues differently. However, an understanding of different judicial approaches adopted across the globe would allow us to approach legal problems in a more holistic manner. This is essentially because in democracies, the fundamental values and goals on the basis of which judges discharge their duties remain similar. Drawing from the experience of compatriots abroad would awaken us to solutions and paths that were never envisaged. It would allow us to understand why our compatriots abroad, when faced with similar dilemmas, preferred one legal solution over the other, and the consequences that followed in the aftermath of such decisions. Further, the non-binding nature of such comparative approaches would provide the flexibility to adopt and modify foreign judicial principles to address local challenges. It is this purpose that this conference seeks to serve. This conference would serve as a marketplace of ideas. We are sure that this conference would provide an opportunity to the participants to engage in informal discussions which would be mutually beneficial. With delegates from more than 20 jurisdictions involved in discussions of topics of general importance to judicial institutions, we hope that you emerge from the conference enriched with the experience and knowledge of your compatriots from across the world. I would prefer to conclude with the words of Sir Isaac Newton, who said, "If I have seen further, it is by standing on the shoulder of giants." Thank you.
Thank you, sir. May I now request the Attorney General of India, Mr. K.K. Venugopal, to address the congregation.
Honorable Prime Minister Shri Narendra Modi, Honorable Chief Justice of India, Justice Sharad Bobde, Honorable Minister for Law and Justice, Shri Ravi Shankar Prasad, Justice Ramana, Justice Arun Mishra, Honorable Justice Nageshwar Rao, esteemed judges from India and abroad, my colleagues at the bar, ladies and gentlemen, I have selected a theme for a very short address, and that is taking poverty to the courts. Now, the first question which would come to the minds of most people would be, what have courts to do with poverty? But what has to be remembered is that so far as India is concerned, when we gave ourselves a constitution, it was a welfare state, and it was a state which had to ensure that the noble promises made in the constitution would be kept. And a state would include not only the legislatures, parliament, the executive, but also the judiciary. And it is here that the question of violation of human rights by not eradicating poverty would arise. It's now very well settled that so far as poverty is concerned, if there is a failure on the part of the state will be violating fundamental rights. Now, the traditional concept of human rights violation is torture, illegal incarceration, violation of freedom of speech. But there is another dimension. If people are allowed to live in substandard human conditions. Now, Scott Lecky, a famous writer, is this to say about poverty. He says, and this is an extract, quote, "However, when people die of hunger or thirst, or when thousands of urban poor and rural developers are evicted from their homes, the world still tends to blame nameless economic or development forces or the simple inevitability of human deprivation before liability is placed on the doorstep of the state." Mary Robinson, the United Nations Commissioner on Human Rights, said, quote, "Extreme poverty is the greatest denial of the exercise of human rights. You don't vote. You don't participate in any political activity. Your views aren't listened to. You have no food. You have no shelter. Your children are dying of preventable diseases. You don't even have the right to clean water. It's a denial of dignity and the worth of each individual, which is what the Universal Declaration proclaims." Now, the question is that one would expect that if there is this sort of poverty, and I will tell you that we have reduced poverty to a very, very low level today in India, you would ask as to how is it that if there is gross violation, there are no food riots, there is no civil disobedience, and so on. But so far as Indians are concerned, they are fatalists. And they have a phrase in one of the languages, Kannada. It is called Hane Baraha, what is written on your forehead. And what they believe is that destiny has condemned them to this state of a life of hunger and suffering. Now, this being so, we find that there is a group of lawyers, social justice lawyers, who have come to the rescue of those suffering from deprivation. And they have approached and have been approached from the very beginning the Supreme Court of India in its original jurisdiction under Article 32 of the Constitution to prevent this horrendous suffering. And the Constitution was adopted in 1950. The census showed that 70% of the people were living below the poverty line. That is what was the state of the country after 200 years of British rule. Now, this has been reduced today to 21%, and that, I think, is through the effort of government. Now, the government has brought in a series of reforms, social reforms, and about 50 of them, and if we could mention a few of them, one is the Mahatma Gandhi National Rural Development Guarantee Act of 2005, providing for social security. The Prime Minister's life insurance scheme for all the poor and deprived. The Prime Minister's People's Wealth Scheme, a financial inclusion scheme that aims to expand and make affordable access to financial services to all. The Prime Minister's All India Mass Medicine Project to make quality medicines available at affordable prices to all, particularly the poor and the disadvantaged. And these are only a few. There are very many. But to cap it all, we have an act recently passed known as the Food Security Act, where food grains are distributed at subsidized rates to about 70% of the people of this country. Now, as I stated, the massive poverty has been reduced and a tremendous dent has been made. But to wherever the state, in the nature of the government, has failed to produce results in some areas where there are gaps, then in such a case, the Supreme Court of India has stepped in. And there are a series of judgments I think which will bring tears to the eyes of people. One is the right to life guaranteed in any civilized society, according to the Supreme Court of India, carries with it the right to food, water, decent environment, education, medical care, and shelter. In another judgment, they said, and this is quoting from Rabindranath Tagore, let the child of the 21st century find himself in that, quote, heaven of freedom, of which our poet laureate Rabindranath Tagore has spoken in Gitanjali, his poem. In another third judgment, the court has said if there is an obligation upon the state to secure to the citizens an adequate means of livelihood and the right to work, it would be sheer pedantry to exclude the right to livelihood from the content of the right to life. But to cap it all, the Supreme Court of India declared that the right of a child to free education up till the age of 14 is a fundamental right. Now, this is something which one would not normally expect from a court, because for the court to elevate a right to a stage, to a level of a fundamental right, and the government accepted this. They amended the Constitution, and under Article 21A, they made this a fundamental right, the right to free education of children up till the age of 14. Now, one would wonder, how is it that so far as the Supreme Court of India is concerned, it is taking on its shoulders what one would at first blush believe that it is an executive power, it's a legislative power, and how does it encroach upon these powers? But what one has to realize is that we are having a welfare state, and we are a developing country, and the problems that the developing country face is different from that of a developed country. And therefore one has to proceed on the basis that the lowest of the low is the one which has to first get priority so far as the Supreme Court is concerned. The Supreme Court went to the extent where we had an article in the Constitution which merely declared that no person shall be deprived of his right to life or liberty other than by a procedure established by law. The court asked itself, what is this right to life? Does it mean a mere animal existence? Or does it mean that a person has to exist with a roof over one's head, with the tools of his trade, with a job, and with food in his stomach? And the court said that all these are essential, otherwise it will be a mere animal existence, and therefore every single individual in this country has a right to live as a full human being. Now, with this interpretation, the apex court of the country did not hesitate in extending the full force of the law to the aid of the sections of the population living in some cases, perhaps in subhuman conditions. And with the collaborative efforts of the Government of India, which has been extending itself with, as I said, with at least about 50 welfare projects, and with the collaborative effort of the Supreme Court of India, the area of reducing poverty of this section of the people, though which is very small today compared to what it was when we obtained freedom, that we could well hope that so far as poverty is concerned, it would be eradicated in the next few years from the face of India. Thank you.
Thank you, sir. May I now request the Judge of the Supreme Court of India, Mr. Justice N.V. Ramana, to please make the introductory remarks.
Shri Narendra Modi, Honorable Prime Minister of India, the Chief Guest of this function. Shri Sarad Arvind Babde, Honorable Chief Justice of India. Shri Ravi Shankar Prasad, Union Minister of Law and Justice. Shri Justice Arun Mishra, Justice L. Nageshwar Rao, Honorable Judges of the Supreme Court of India, Shri K.K. Venugopal, Attorney General of India, respected delegates and representatives from across the globe, Honorable Chief Justice and Judges of the High Court, Solicitor General of India and other law officers, Chairman of Bar Council of India, President and members of the Executive of the Supreme Court Bar Association, respective advocates, directors of judicial academies, member secretaries of legal service authorities, members of the press, ladies and gentlemen, good morning, namaskar. I must state that it gives me great pleasure to welcome this august gathering comprising of judges, juries, and law practitioners from across the world, and to introduce the topics that we are going to discuss in this conference. The magnitude of the event is compounded by the fact that we have representatives from more than 24 countries who have come to share their experience with us. This reminds me the Indian ethos, which strongly believe in Vasudhaiva Kutumbakam. This Sanskrit phrase means that the entire world constitutes one family. This conference provides a wonderful opportunity to meet our brothers and sisters from across the world and from lasting relations. Presently, our globalized world is closer than it seems. Issues are common and solutions need to be unanimous. Major issues which are plaguing the world, including the Indian subcontinent, are terrorism, cyber crimes, environmental degradation, and health. For example, this is one of the main issues which has affected every part of the world and has no end in sight. The judiciary needs to appropriately respond to this problem by evolving innovative principles and jurisprudence so that terrorism is kept at bay, while at the same time upholding the rule of law. More importantly, globalization demands rule of law. With the increase in cross-border dealings, movements of citizens, goods and investment, there is a requirement of stronger trust between nations. This trust can be built by creating institutions with strong emphasis on the rule of law, which creates a secure environment. India has contributed to the evolution of jurisprudence in many areas, and our judgments have been cited with acceptance overwhelmingly by other jurisdictions such as the United Kingdom, Australia, Singapore, Bangladesh, and other countries in the Asian continent. A special mention needs to be made of Justice Michael Kirby, who had studied Indian jurisprudence and has cited our judgments in umpteen number of Australian High Court judgments. Indian legal system is based on the separation of powers, independence of the judiciary, and constitutional courts with wide jurisdiction. We have a constitution which enumerates fundamental rights and duties. This constitution has been expounded by the Supreme Court in terms of the constitutional morality to make it relevant from time to time. The decision rendered by the courts in India certainly reflects the strong democratic culture prevalent in India. In our country, there is a free statutory legal aid program which covers almost 75% of the Indian population. This year, we are celebrating 25 years of the successfully providing legal aid to the poor. Another important feature is that there are nearly 64,000 panel lawyers and around 69,000 paralegal volunteers who are regularly rendering legal aid and conducting legal awareness programs. Coming to the specific topics chosen for the various sessions, it can be seen that they have international ramifications. I hope that some ideas for solutions evolve through a discussion based on the experience and expertise of the esteemed participants from different jurisdictions. The first topic, the role of judiciary in maintaining a gender-just world. The gravity of this topic stems from the fact that women constitute half the world's population, perform nearly 2/3 of work hours, receive 1/10 of the world's income, and own less than 0.01% of the world's property. Most nations have recognized equality and dignity of women, whether under the Constitution or otherwise. We have all realized that merely having a lofty declarations in law would not satisfy the requirement to uplift women who are discriminated day in and day out. There is sufficient scope for the judiciary to proactively ensure a gender-just world. In this context, we should realize that there cannot be any compromise in gender equality. The second session concerned the topic, Role of Judiciary Against Populism. Rule of law is the strongest tool which protects plurality. This urges judicial readiness to intervene, but only when necessary to correct or prevent a problem what will likely to not be resolved. This topic assumes fundamental importance because populist decisions affect the constitutional rights, and more often than not, rights of one group are pitted against the rights of or interests of the other group. Hence, courts have to rise to the occasion and guard constitutional values, at the same time balance all constitutional considerations. The third session pertains to the Constitution and its interpretation, which is the subject which has never had any unanimity in this approach. Internationally, a facet of constitutional interpretation has been brought to the forefront by judges like Lord Denning, Justice Marshall, Breyer, Rajendra Gadkar, Hidayatullah, Vivian Bose, and Justice Koka Subbarao. India's most prominent contribution to this debate is the evolution of the doctrine of basic structure in the celebrated case of Kesavananda Bharati versus State of Kerala. This doctrine evolved from the fact that a constitution is not merely a document laying down the grand norm. Rather, it is a process which binds generations after generation to certain promises we made ourselves, while normatively imagining what our country would be. In this context, this subject requires deeper consideration based on the differing experiences of the judicial minds from across the continents and how they have dealt with the question. The fourth session concerns the topic, the role of judiciary in environmental protection and sustainable development. This topic reminds me of Mahatma Gandhi, who observed that, I quote, the future depends on what we do in the present, unquote. This issue has been a point of discussion since the beginning of this century and continue to be a main focus within global politics. The threat of environmental degradation is not mere hypocrisy or hysteria. It is real, and we are suffering the consequences of the same every day. Recently, we have witnessed earth-shattering environmental crises such as forest fires, depletion of ozone layer, climate change, increasing sea levels, etc. We must all realize these efforts are not only for the present generation, but also are a noble task to create a safe and sound environment for future generations. The fifth and final session of the conference, titled The Role of Judiciary in Protecting Privacy of Citizens in the Internet Age, is a fitting finale to this international conference, as it directly confronts an issue that concerns global citizenry pertaining to the changing geological landscape. As individuals are provided the services over the internet by international entities, there is a need to create a jurisprudence that molds together both international and national concerns. Therefore, this topic is extremely well suited to a broad-based cross-jurisdictional discussion such as the present, and it would be illuminating to hear your concerned inputs on this age right. Before I end, I am reminded Martin Luther King, who observed that, I quote, "If we are to have peace on earth, our loyalties must transcend our race, our tribe, our class, and our nation. And this means we must develop a world perspective," unquote. With these few words, I would like to conclude by encouraging all of you to actively take part in the sessions and forthcoming in the discussions. I hope that these 2 days are enlightening, stimulating, and would go a long way in breaking barriers, making lifelong friends, and creating long-lasting memories. Thank you.
Thank you very much, sir. May I now request the Union Minister for Law and Justice, Communications, Electronics and Information Technology, Mr. Ravi Shankar Prasad, to please address the Assembly.
Honorable the Prime Minister of India, forgive a little sore throat, ladies and gentlemen. Honorable the Chief Justice of India, Mr. Bobde, distinguished judges of Supreme Court, Attorney General, Solicitor General, law officers, honorable judges of Supreme Court, Chief Justice of High Court, judges, and distinguished delegates from abroad. Welcome to India, where we are proud of our heritage, where we celebrate our diversity, where we are committed that the only way of growth and development is democracy, where people have the right to elect their leaders. And above all, our abiding commitment to the rule of law and in the glorious identity of an independent judiciary. That is what our primary constitutional value is about. The last 70 years of our journey after becoming independent is a glorious journey where, in spite of many challenges, we have sought to keep our democratic commitment in focus, respected the challenges and the resolution which the judiciary gave and the country accepted. If we see the last 70 years of the march of India, all the issues, complicated challenges which could arise anywhere in the world, India has to face, of race, of religion, of language, of caste, of community and region. They were challenging times. While the polity responded, the Supreme Court, the shining beacon of our judicial system, came with judicial resolutions and the country accepted. That has been the great march of our democracy, which we celebrate. Therefore, rule of law, which we are going to talk about, in my very considered view, contains two elements. One is fairness, the second is justice, and the third is certainty. These three elements must always comprise the rule of law principle which we are going to talk about. I was just mentioning Honorable the Chief Justice in the morning that I was very much impressed by the topics we have selected for deliberations. Gender justice is something we are very proud of. Gender justice is the core of India's constitutional ethos. Fundamental right against discrimination on the ground of religion and sex. Today, India is very proud as to how Indian women are doing so well. You can see so many women judges sitting here of High Courts and Supreme Court, including Chief Justices. Our Prime Minister has taken the lead in empowerment of women in India. Beti Bachao, Beti Padhao. Educate the girl child, develop the girl child. As an IT Minister, I am proud to share that India is home to some of the finest creation of IT initiatives, globally recognized. 40 lakh, 4 million professionals work in India's IT sector. 1/3 are women. And indirectly, close to 10.4 million professionals work there. Close to half are women. Our Prime Minister was bold enough to permit that Indian Air Force pilots will also fly the fighter planes. And this was complemented by the recent judgment of Supreme Court, where Indian women army officers were given the right to command. I think these are great initiatives of our gender empowerment. There are challenges of victimization, of tormenting women, young girls, and we responded, making rape law tougher, including capital punishment, establishing more than 1,000 fast-track courts. And surely it is a work in progress where we have to ensure that while we celebrate Indian women scientists joining the space program for Mars, but should also get justice. That is the opportunity and also the challenge. The second issue is populism and challenges of justice. In a democracy, we welcome dissent. We welcome populism too. We have a problem also when populism impinges upon well-settled constitutional principles. And populism also becomes a problem when those who have been rejected in the popular mandate becomes the biggest flag bearers of populism. In our constitutional scheme, ladies and gentlemen, it's very clear that government must be left to those elected by people of India to govern. And obviously, they have to be accountable to the parliament, in many ways to judicial decisions, and also to the people after elections. But what is challenging is that now populism is seeking to have greater accountability as to what kind of judgment there should be. I'm a great supporter of social media, of freedom. I know it is empowering, but this is a dangerous trend. Judges must be left completely independent to give judgment as to what they think is the correct mode in accordance with the rule of law. But this sinister trend of late developing globally and also in our country, that some people start campaigning as to what kind of judgment they expect. And the judgment is not in accord with that, and unleashing all the forces of criticism. Criticizing the judiciary, I always appreciate of the judgment. But some kind of norm has to be maintained if our rule of law has to acquire continued resonance. Privacy, as Mrs. Ramana just stated, has been held to be a fundamental right, and we appreciate that. Supreme Court judgment has become a beacon globally. Wonderful judgment being talked about. We're very proud. The right to privacy flows from Article 21, the right to life and the right to live with dignity. And our courts have also stated that terrorists and corrupt have no right to privacy, because the right to privacy has acquired critical proportion in the wake of digital landscape expanding globally. This is the age of information, information is power. This is the age of communication, communication is power. And we in India, ladies and gentlemen, to my foreign delegates, I want to give one statistics. India's population 1.3 billion, mobile phone 1.21 billion, and the digital identity card Aadhaar to supplement your physical identity 1.25 billion. So we Indians only talk in billions, but obviously it is giving rise to a lot of data. Data is important. We need to have a proper balance, and the balance is we accord constitutional sanction to the right of privacy, but we should not kill innovation. We should not kill application of new technology. Our courts have recognized that exception. India today has become the third biggest startup ecosystem in the world. And Mr. Venugopal was talking about the challenges of poverty. How we are tackling technology to alleviate poverty. I want to give you only one number. Under the leadership of the Prime Minister, we are sending welfare measures directly to the bank account of the poor, so that there is no leakage. We opened 370 million bank accounts of the poor. And in 429 government welfare schemes, we have sent 129 billion US dollars, 9.22 lakh crore in the last 5 years, directly to the bank account. And how much we have saved? 1.70 lakh crore, 23.8 billion US dollar, which used to be pocketed by middlemen and fictitious claimants. And the third number is all the more hilarious. We have removed 8 crore, 80 million fake beneficiaries. Therefore, digital ecosystem also empowers. But we have to respect the privacy. And most important, terrorists should not abuse this system. Mr. Justice Ramana rightly pointed out. Why? Internet is one of the finest creations of human mind. This should not be abused by few. And we need to acknowledge that some of the biggest terrorist threat have also emanated by those who have abused this great invention of human mind. I think that kind of balance has to be there. Therefore, from gender justice to the issue of privacy to the issue of populism, these are challenges. I don't want to further deliberate as to how we are meeting these challenges by changes of law, by trying to make India a big hub of arbitration, by promoting commercial court movement for trade, addressing the good sense of ease of doing business, and also promoting alternative legal address mechanism by Lok Adalat. Those are well known, we'll talk about it. But what we are very proud of, that we trust our democratic values, we trust our judiciary, and we trust the common instinct of ordinary Indians to select the leaders they want them to govern. When we take all these into account, we have to have a balance. The rights and the duties. The identity and the obligation. And most important, is speak your mind. Be critical. Ask questions. But it all should work in a manner that the identity of India as a country continues to remain strong and resurgent. Ladies and gentlemen, this is time for global challenges, for institutions, judiciary, and state. Questions are being asked. How do we seek resolution? That remains an important question. The meeting of some of the finest minds of the world today in this conference, I wish to congratulate the Chief Justice, will surely find an answer. And I'm clear, the only answer is to fall back upon the conventional regulatory mechanism of being governed by rule of law. Thank you. Namaskar. Jai Hind.
Thank you, sir. May I now request the Chief Justice of India, Mr. Justice Sharad Bobde, to please address the August Assembly.
Good morning to you all. Shri Narendra Modi, the Honorable Prime Minister of India, Shri Ravi Shankar Prasad, the Honorable Union Minister for Law and Justice, my esteemed colleague Justice Ramana, Justice Arun Mishra, Justice Nageshwar Rao, the Attorney General for India, Shri Venugopal, my distinguished brother and sister judges of the Supreme Court of India, Honorable Chief Justices and judges of the many countries, Chief Justices and judges of the High Courts, the Solicitor General, the Chairman Bar Council, the SCBA President, the SCORA President, senior advocates, and there is a large section of academics, all of them, the directors of the academies, the vice chancellors, members of the press, the Secretary General, ladies and gentlemen. It is my proud privilege to welcome you all to the first ever international conference hosted by India under the aegis of the Supreme Court of India. I extend my gratitude to the Prime Minister Narendra Modi for having accepted our invitation to grace this event. I am delighted with the response that my brethren in robes have shown in attending this international dialogue about the judiciary and the changing world. Justice Bhandari from the International Court of Justice also found the time to be with us today. The zeitgeist of our times has been incredible technological development. The entire world today is interconnected like the World Wide Web itself, and a small change in one corner of the world can result in changes in different parts of the world. Judiciaries all over the world are dealing with this kind of change, what might be called a rights revolution, a technological revolution, and a demographic revolution. Our decisions no longer impact only those who live within our jurisdictions, but also those who live in other jurisdictions, some very far away. A conference like this offers opportunities for dialogues between judges from various jurisdictions in the world to exchange ideas and gain knowledge from each other on many aspects of gender justice, right to privacy, populism, environment, and sustainable development. I won't go into the details of the subjects. That India is a melting pot of myriad cultures and traditions is well known. This is equally true of its judicial system and institutions. We have assimilated legal cultures of all civilizations who have come to our shores. The Mughals, the Portuguese, the French, the Dutch, and finally the English. Right from conventional court systems to customary methods of adjudication, our rules of evidence are not only the conventional rules based on the Anglo-Saxon Evidence Act. There is a diverse mixture of traditions of the past infused with the present, looking toward the changing time. In the northeast of this country, it might be interesting for members from foreign jurisdictions to know, there is a chicken liver test which is employed to determine the guilt in the absence of direct evidence. The priest selects a small chick, cuts his neck, removes its liver, examines it, and hands it over to the other members of the court, the panchayat, for examination. The panel then decides collectively on whether the accused is guilty, post the examination of the liver. There is also the practice of taking oath by holding the tooth of a tiger. I think the implied condition is that if he lies, a tiger will kill him. This is the fascinating diversity, and there's a book by the Supreme Court which deals with this diversity. Before these cultures reached our shores, India had a well-established system of courts. The rules were all contained in scriptures which prescribed an open hearing in courts. I am talking of ancient times. in the presence of officers of the court. For example, the Vyas Smriti provides the various stages for a valid decision. They are these: the plaint, the written statement, issues, evidence, its analysis, arguments of the lawyers, provisions of law, and finally, that the decision should be of the members of the bench. The last requirement is that the judgment should have a royal seal. It seems nothing has changed too much over the years. Interestingly, there is in the Smriti a definition of what definition should be. It says the definition should be precise, unequivocal, having universal meaning, universally capable of understanding. It should not be plagiarized and not prohibited from being stated openly. I recall these ancient traditions only to emphasize that a well-structured judicial system is about 2,000 years old in this country or more, and has always been at the bedrock of India's legal history. Our Constitution is magnificent, not just for its detail, but also for the international inspiration that it drew and continues to draw. The Constitution makers embraced a famous saying from the Rig Veda, which is Ano Bhadraha Krutavo Yantu Vishwataha, which means let noble thoughts come to us from all universe. The founding fathers of this post-colonial country studied various models of the Constitution from all directions. There were former dominions of the British Empire, such as Ireland and Australia, where the British system of governance was adopted in the form of a constitution. There was Japan, where after the World War a constitution was given to them by the victors. There was the United States of America, where individual rights formed the very basis of their constitution. There were many constitutions of France, most of which embodied the principle of justice, liberty, and equality. The Constitution of India therefore synthesized what is probably the perfect blend of all that came before it and tailored it to fit this country's diversity and thought. At the heart of the Constitution was the individual, and the rights of individual were recognized as fundamental. These rights have been beautifully balanced with demands of public order, morality, and health. Amongst the dominant thoughts when the Constitution was being drafted was a thought by the great Swami Vivekananda, who said, I thought it was a very modern thought, liberty of thought and action is the only condition of life, of growth and well-being. Where it does not exist, the man, the race, the nation or institution which bars the power of free thought and action of an individual, even so long as that power does not injure others, it is devilish and must go down. A feature often neglected in our Constitution is a chapter of fundamental duties, which was not there originally. Imposing on every citizen the duty is to abide by the Constitution, the whole of it, and respect its ideals and institutions. You know, the Mahatma, that is Mahatma Gandhi, once said, the exercise of rights depends on one's sense of duty. This follows from what he had written in Hindi Swaraj, where he argued that real rights are a result of performance of duty. Modern jurists might think that Gandhiji was obsessed with duties, but he thought that duties were all important. And there is a part where he said, a part of his talk where he says that if everybody performs his duty, all rights are taken care of. This is how he dealt with the duties of citizens. The Constitution also created a strong and independent judiciary which was separated from the executive and the legislature. We have strived at every turn, not just as an institution, but also as a citizenry, to keep these basic ideals intact. Probably the most fundamental feature of most constitutions is the idea of the rule of law. And that is certainly the motto of the Indian Supreme Court, which says, where there is adherence to law, there is victory. Yato dharmas tato jayaha. After we gave the Constitution to ourselves, it fell upon this judiciary to interpret it. The judiciary, right from 1950, looked for inspiration from across the globe to find creative solutions to constitutional problems. It is interesting that in the first important case on fundamental rights, A.K. Gopalan's case, the Supreme Court quoted law from the American, Japanese, Irish, Canadian, and English courts. Ever since, we have not shied away from looking for inspiration. Conferences such as these, in a sense, celebrate this universality and seek a better expression through the challenges that the judiciaries of the world face. Undoubtedly, the success of the rule of law in our country depends on how the judiciaries respond to such challenges and how they emerge from these challenges. I do hope that at the end of the conference, all of us would be benefited by learning from each other and have a clearer definition of the roles of the judiciary in the changing world. In this spirit, I warmly welcome you all to this conference. Thank you. Jai Hind.
Thank you very much, sir. May I now request our chief guest, the Honorable Prime Minister of India, Mr. Narendra Modi ji, to please share his thoughts with us.
Chief Justice of India, Justice Bobde, कानून मंत्री श्रीमान रविशंकर प्रसाद जी, मंच पर उपस्थित सुप्रीम कोर्ट के न्यायाधीशगण, अटॉर्नी जनरल ऑफ इंडिया, इस कॉन्फ्रेंस में दुनिया भर से आए हुए अन्य उच्च न्यायालयों के सभी आदरणीय न्यायाधीश, भारत के सुप्रीम कोर्ट और हाई कोर्ट्स के सम्मानित जजेस, अतिथिगण, देवी और सज्जनों, दुनिया के करोड़ों नागरिकों को न्याय और गरिमा सुनिश्चित करने वाले आप सभी दिग्गजों के बीच आना अपने आप में एक सुखद अनुभव है। न्याय की जिस चेयर पर आप सभी बैठते हैं, वो सामाजिक जीवन में भरोसे और विश्वास का महत्वपूर्ण स्थान है। मैं हृदयपूर्वक आप सबको बहुत बहुत बधाई देता हूं, आपका अभिनंदन करता हूं। साथियों, ये कॉन्फ्रेंस 21वीं सदी के तीसरे दशक की शुरुआत में हो रही है। ये दशक भारत सहित पूरी दुनिया में होने वाले बड़े बदलावों का दशक है। ये बदलाव सामाजिक, आर्थिक और तकनीकी हर मोर्चे पर होंगे। ये बदलाव तर्कसंगत होने चाहिए और न्याय संगत भी होने चाहिए। ये बदलाव सबके हित में होने चाहिए, भविष्य की आवश्यकताओं को देखते हुए होने चाहिए और इसलिए जुडिशरी एंड द चेंजिंग वर्ल्ड, इस विषय पर मंथन मैं समझता हूं बहुत ही महत्वपूर्ण है। साथियों, भारत के लिए बहुत सुखद अवसर भी है कि महत्वपूर्ण कॉन्फ्रेंस आज उस कालखंड में हो रही है जब हमारा देश राष्ट्रपिता महात्मा गांधी की 150वीं जन्म जयंती मना रहा है। पूज्य बापू का जीवन सत्य और सेवा को समर्पित था, जो किसी भी न्यायतंत्र की नींव माने जाते हैं। और हमारे बापू खुद भी तो वकील थे, बैरिस्टर थे और अपने जीवन का पहला मुकदमा उन्होंने लड़ा। उसके बारे में गांधी जी ने बहुत विस्तार से अपनी आत्मकथा में लिखा है। गांधी जी तब बंबई, जो आज का मुंबई है, वहां थे। संघर्ष के दिन थे। किसी तरह पहला मुकदमा मिला था, लेकिन उन्हें कहा गया कि उस केस के एवज में उन्हें किसी को कमीशन देना होगा। गांधी जी ने साफ कह दिया था कि केस मिले या न मिले, कमीशन नहीं दूंगा। सत्य के प्रति, अपने विचारों के प्रति गांधी जी के मन में इतनी स्पष्टता थी। और ये स्पष्टता आई कहां से? उनकी परवरिश, उनके संस्कार और भारतीय दर्शन के निरंतर अध्ययन से यह निकला है। फ्रेंड्स, भारतीय समाज में रूल ऑफ लॉ सामाजिक संस्कारों का आधार है। हमारे यहां कहा गया है, क्षत्रयस्य क्षत्रम यत धर्म, यानी लॉ इज द किंग ऑफ किंग्स, लॉ इज सुप्रीम। हजारों वर्षों से चले आ रहे ऐसे ही विचार एक बड़ी वजह है कि हर भारतीय की न्यायपालिका पर अगाध आस्था है। साथियों, हाल में कुछ ऐसे बड़े फैसले हुए हैं जिनको लेकर पूरी दुनिया में चर्चा थी। फैसले से पहले अनेक तरह की आशंकाएं व्यक्त की जा रही थी, लेकिन हुआ क्या? 130 करोड़ भारतवासियों ने न्यायपालिका द्वारा दिए गए इन फैसलों को पूरी सहमति के साथ स्वीकार किया। हजारों वर्षों से भारत न्याय के प्रति आस्था के इन्हीं मूल्यों को लेकर आगे बढ़ रहा है। यही हमारे संविधान की भी प्रेरणा बना है। पिछले वर्ष ही हमारे संविधान को 70 वर्ष पूरे हुए हैं। संविधान निर्माता डॉक्टर बाबा साहब आम्बेडकर ने कहा था, कॉन्स्टिट्यूशन इज नॉट अ मियर लॉयर्स डॉक्यूमेंट, इट इज अ व्हीकल ऑफ लाइफ एंड इट्स स्पिरिट इज ऑलवेज ए स्पिरिट ऑफ एज। इसी भावना को हमारे देश की अदालतों, हमारे सुप्रीम कोर्ट ने अपने अपने समय में आगे बढ़ाया है। इसी स्पिरिट को हमारी लेजिस्लेचर और एग्जीक्यूटिव ने जीवंत रखा है। एक दूसरे की मर्यादाओं को समझते हुए तमाम चुनौतियों के बीच कई बार देश के लिए संविधान के तीनों पिलर्स ने उचित रास्ता ढूंढा है और हमें गर्व है कि भारत में इस तरह की एक समृद्ध परंपरा विकसित हुई है। बीते 5 वर्षों में भारत की अलग अलग संस्थाओं ने इस परंपरा को और सशक्त किया है। देश में ऐसे करीब 1500 पुराने कानूनों को समाप्त किया गया है, जिनकी आज के दौर में प्रासंगिकता समाप्त हो रही थी। और ऐसा नहीं है कि सिर्फ कानून समाप्त करने में तेजी दिखाई गई है। समाज को मजबूती देने वाले नए कानून भी उतनी ही तेजी से बनाए गए हैं। ट्रांसजेंडर पर्सन्स के अधिकारों से जुड़ा कानून हो, 3 तलाक के खिलाफ कानून हो, या फिर दिव्यांग जनों के अधिकारों का दायरा बढ़ाने वाला कानून, सरकार ने पूरी संवेदनशीलता से काम किया है। फ्रेंड्स, मुझे खुशी है कि इस कॉन्फ्रेंस में जेंडर जस्ट वर्ड के विषय को भी रखा गया है। दुनिया का कोई भी देश, कोई भी समाज जेंडर जस्टिस के बिना पूर्ण विकास नहीं कर सकता और न्यायप्रियता का दावा कर सकता है। हमारा संविधान राइट टू इक्वलिटी के तहत ही जेंडर जस्टिस को सुनिश्चित करता है। भारत दुनिया के उन बहुत कम देशों में से एक है जिसने स्वतंत्रता के बाद से ही महिलाओं को वोट देने का अधिकार सुनिश्चित किया। आज 70 साल बाद अब चुनाव में महिलाओं का ये पार्टिसिपेशन अपने सर्वोच्च स्तर पर है। अब 21वीं सदी का भारत इस पार्टिसिपेशन को दूसरे पहलुओं में भी तेजी से आगे बढ़ा रहा है। बेटी बचाओ बेटी पढ़ाओ जैसे सफल अभियानों के कारण पहली बार भारत के एजुकेशनल इंस्टीट्यूशंस में गर्ल चाइल्ड का एनरोलमेंट लड़कों से ज्यादा हो गया है और किसी भी हिंदुस्तानी को इस बात का गर्व होगा। इसी तरह सैन्य सेवा में बेटियों की नियुक्तियां हो, फाइटर फ्लाइट्स की चयन प्रक्रिया हो, माइंस में रात में काम करने की स्वतंत्रता हो, सरकार द्वारा अनेक बदलाव किए गए हैं। आज भारत दुनिया के उन कुछ देशों में शामिल है जो देश की कैरियर वुमेन को 26 हफ्ते की पेड मैटरनिटी लीव देता है। साथियों, परिवर्तन के इस दौर में भारत नई ऊंचाई भी हासिल कर रहा है, नई परिभाषाएं गढ़ रहा है और पुरानी अवधारणाओं में बदलाव भी कर रहा है। एक समय था जब कहा जाता था कि तेजी से विकास और पर्यावरण की रक्षा एक साथ होना संभव नहीं है। भारत ने इस अवधारणा को भी बदला है। आज जहां भारत तेजी से विकास कर रहा है, वहीं हमारा फॉरेस्ट कवर भी तेजी से एक्सपांड हो रहा है। 5-6 साल पहले भारत विश्व की 11वीं सबसे बड़ी अर्थव्यवस्था था। 5 साल पहले, 3-4 दिन पहले जो रिपोर्ट आई है उसके मुताबिक अब भारत विश्व की 5वीं सबसे बड़ी अर्थव्यवस्था है। यानी भारत ने यह करके दिखाया है कि इंफ्रास्ट्रक्चर निर्माण के साथ साथ एनवायरनमेंट को भी सुरक्षित रखा जा सकता है। साथियों, मैं आज इस अवसर पर भारत की न्यायपालिका का भी आभार व्यक्त करना चाहता हूं, जिसने विकास और पर्यावरण के बीच संतुलन की गंभीरता को समझा है, उसमें निरंतर मार्गदर्शन किया है। अनेक पब्लिक इंटरेस्ट लिटिगेशन पीआईएल्स की सुनवाई के दौरान सुप्रीम कोर्ट ने भी पर्यावरण से जुड़े मामलों को नए सिरे से परिभाषित किया है। साथियों, आपके सामने न्याय के साथ ही शीघ्र न्याय की भी चुनौती हमेशा ही रही है। इसका एक हद तक समाधान टेक्नोलॉजी के पास है। विशेष तौर पर कोर्ट के प्रोसीजरल मैनेजमेंट को लेकर इंटरनेट आधारित टेक्नोलॉजी से भारत के जस्टिस डिलीवरी सिस्टम को बहुत ही लाभ होगा। सरकार का भी प्रयास है कि देश की हर कोर्ट को ई कोर्ट इंटीग्रेटेड मिशन मोड प्रोजेक्ट से जोड़ा जाए। नेशनल जुडिशियल डाटा ग्रिड की स्थापना से भी कोर्ट की प्रक्रियाएं आसान बनेगी। आर्टिफिशियल इंटेलिजेंस और मानवीय विवेक का तालमेल भी भारत में न्यायिक प्रक्रियाओं को और गति देगा। भारत में भी न्यायालयों द्वारा इस पर मंथन किया जा सकता है कि किस क्षेत्र में, किस स्तर पर उन्हें आर्टिफिशियल इंटेलिजेंस की सहायता लेनी है। इसके अलावा बदलते हुए समय में डेटा प्रोटेक्शन, साइबर क्राइम जैसे विषय भी अदालतों के लिए नई चुनौती बनकर उभर रहे हैं। इन चुनौतियों को ध्यान में रखते हुए ऐसे अनेक विषयों पर इस कॉन्फ्रेंस में गंभीर मंथन होगा। कुछ सकारात्मक सुझाव सामने आएंगे। मुझे विश्वास है कि इस कॉन्फ्रेंस से भविष्य के लिए अनेक बेहतर समाधान भी निकलेंगे। एक बार फिर आप सभी को बहुत बहुत शुभकामनाओं के साथ इस समिट की सफलता के लिए मेरी शुभेच्छाओं के साथ साथ इस मंथन से जो अमृत निकलेगा वो न सिर्फ भारत को, लेकिन नई ऊंचाइयों को प्राप्त करने की मशक्कत कर रहे विश्व को भी अवश्य उपयोगी होगा। इसी भावना के साथ मेरी शुभकामनाओं को कहते हुए मेरी वाणी को विराम देता हूं। बहुत बहुत धन्यवाद।
Thank you very much, Mr. Prime Minister, sir, for your stimulating address. In conclusion, may I request the Judge of the Supreme Court, Mr. Justice Arun Mishra, to please give the vote of thanks.